Hear me?
Yes, I can hear you.
Okay, so I think we lost Mr. Bulus. Okay.
Okay. Um, Thank you for those feedbacks we have gotten. Thank you, Mr. Chukwuma. Thank you, Mr. Bulus. Um, I, I do not know if my chairman is on the call yet. My branch chairman. Let me confirm. Not yet. I've not seen him. Okay, he's not here. So on behalf of my branch chairman, the chairman of Gariki branch, the person of Anthony Bamidele Ojo Esquire, we welcome you to day two of the surrogacy webinar being organized by the Medical and Health Law Committee of MBA Gariki branch. Without much wasting of time, we will head into today's training. For the benefit of those who were not here yesterday, I will quickly introduce our presenter so that she takes the floor after now. Okay. Undiga Emwekbere Mrs. is a seasoned and experienced international fertility law expert of 25 years post-call. She holds an LLB degree from a Nigerian university and a LLM degree from London, with dual qualification to practice law in Nigeria as well as England and Wales. She possesses over 15 years practical experience in international surrogacy, transnational child adoption, garment donation, and posthumous conception. She also provides services for families navigating immigration, citizenship, or documentation process for a surrogate born or donor conceived children. She is the principal and lead consultant at Okamara Law and Consulting. Ladies and gentlemen, please join me in welcoming for day two presentation the person of Madam Undiga Emwekbere. Thank you very much. I'm not seeing your applause on the chat box. I'm not seeing excitement. I am not seeing welcoming icon. Thank you very much, David Essien. Thank you. Madam, you may carry on. Thank you.
Good afternoon, everyone.
Good afternoon.
Thank you again to MBA Garki and the medical committee and my friend and brother Ebenezer Guatu. Thank you for this wonderful opportunity to share my knowledge and experience with us. So today is day two. Unfortunately, for those of you who were not here yesterday, I'll be building on the foundations of, I'll be leaning a lot on the foundations of what we did yesterday. And I guess NBA Gariki has said that they will provide the recordings. So you could mop it up from that on your own after today, after this presentation. So for day two, we're looking at, yesterday we looked at surrogacy in Nigeria, we looked at the legal foundations, we looked at the legal issues that need to be addressed. We took a deep dive into the functions of a surrogacy or an assisted reproductive technology act, what it's an ideal one should look like, what it should do, the provisions it should contain, and the functions that it plays. And then we looked at the present surrogacy bill, which we have going through the House of Representatives at the moment, and we evaluated it to some extent to see how it shaped up with the ideal situation that we had outlined at the beginning of our presentation. So today we are going into a more practical aspect of things, which I think a lot of people will be more interested in. We're looking at surrogacy practice in Nigeria. what lawyers do, and I'm sure you'll be very excited by billing and the attendant challenges of practicing in an area where there is no regulatory framework. I think by way of outline, Ebenezer has taken care of the introduction. I will be looking at the context. So yesterday we looked at the law, but today we're looking at the context. What is the context? What's the environment in which this surrogacy practice is happening in Nigeria? Both from a general perspective of what's going on in the country in respect of assisted reproduction, what's happening regarding the people who are engaging in these practices, and then finally drilling down into the role of the lawyers in all of this. And then we will talk about billing, getting paid for your work, because of course, unless you're doing pro bono, you expect to earn a living and get paid for what you do. We'll be looking in a little bit at the legal remuneration order of 2023 to see what guidance it provides us in this respect. A little housekeeping. I won't be going over my introduction, but I'd like to say a few things about my background to give you an idea of how my thinking process and my, if you like, my expertise has been shaped. Because I get a lot of inquiries from young lawyers who want to know how I got where I am. So I always start by saying that even though I have practice rights in England and Wales, I am a Nigerian lawyer first and foremost. And whatever I do is built on a solid foundation of a Nigerian emphasis on Nigerian legal education. I went to the one and only University of Nigeria. If there are lions in the house, drop a heart in the chat box. I do have an LLM in international business law, which kind of makes a little difference. And I have a lot of UK fertility legal experience. That's actually where I got into the profession, into that practice area by practicing fertility law in the UK. And I also have 10 years plus of UK legal lecturing experience in a UK university. So the point I'm trying to make is that all the little bits of experience that you get wherever you've been, they count, as long as they touch on the law and they are useful. So your pathway might not necessarily be the same way as mine, but the most important thing is that you acquire the requisite knowledge and the requisite transferable skills. And so in terms of my approach, I would say that my approach for this particular presentation is transactional in terms of we're looking at what we're doing for the clients, but I also have an eye out for the ethics. And yes, we are Nigerian lawyers and we're talking about domestic surrogacy, but to a great extent, what we do here is guided by the international context, because in Nigeria, we are attracting a lot of foreigners and Nigerians from the diaspora who come to Nigeria for fertility treatment. So in terms of context, we have a high infertility rates as classified by the World Health Organization, which puts Nigeria in what it classifies as the infertility belt. We have high poverty levels. We have a high cultural preference and premium placed on procreation and the continuation of lineage. If you're Igbo, you will know the meaning of the name Obiechina. May my lineage not end. In almost each and every ethnic group in Africa, not talk less of Nigeria, you have this emphasis on wanting to extend your bloodlines into the future by having children, and not just having children, having male children. So we have a very strong preference for male children. And many people do not know that Nigeria is quietly becoming a leading fertility treatment destination on the African continent. We have a highly developed fertility medical practice. Yesterday, I saw that there were quite a few Nigerian fertility doctors who attended the webinar. We have very competitive success rates for our IVF, our surrogacy treatments in Nigeria. We have a good supply of donor egg, sperm, and surrogates. And we also have a very high number of Nigerians from the diaspora and foreigners who come to Nigeria seeking fertility treatment. But we also have to look at the problems that we have in Nigeria. We have a lot of problems internationally with the credibility of our documents. We have a lot of issues with people playing fast and loose with documents and actually actively falsifying documents. And unfortunately, some of our colleagues are involved in this. Nigeria is considered a hotbed of human trafficking. Um, and we have a lot, even though we have a thriving assisted reproductive technology industry, it is largely unregulated, which gives rise to a lot of legal uncertainty and the high potential and prevalence of exploitative practices. And we also have, because of all these things put together, we have problems with being able to take surrogate born or donor conceived children out of Nigeria to the countries where their parents want them to live and be raised. There's also a high levels of ignorance and lack of awareness of the legal implications of assisted reproductive technologies and particularly surrogacy. Like we were taught in law school, the first thing we need to do is to understand our clients' needs. Whether we like it or not, we've been given a whole lot of training and indoctrination about how we are professionals and we are called to very high professional standards, which is true. But at the end of the day, it is your law firm is a business. It's a business which is based on the exercise of professional skill and expertise, which is based on the provision and payment for um, legal services. And so if you look at your law firm from that perspective, you're a service provider. And the heart, the raison d'etre of a service provider is being able to understand and satisfy your client's needs. So in terms of understanding your client's needs, when somebody comes to you and the person has been involved in a surrogacy, what exactly do they want from you as a legal practitioner? The first thing they want is sometimes the clients don't even know what they need, but your job as a legal practitioner is to tell them what they need, not just what they want from you, and make sure that they get it. So the first thing that somebody who is involved in surrogacy needs is to acquire parental rights over the surrogate born child or the donor conceived child. And that requires the termination of the legal motherhood of the surrogate, and anybody who may claim or may be able to exercise to assert parental rights against that child through her. And that would usually be a spouse or a boyfriend or a significant other. The second need is proper documentation, and that proper documentation refers to how that child was brought about regarding the fertility treatment. If there was an egg or sperm donation, we want to see embryology reports and verifiable documentation to show where that egg came from, where that sperm came from. We want to see evidence about of how that surrogacy was managed. Was it managed by the clinic? Was it managed by a surrogacy agency? Was it a licensed surrogacy agency? Is there documentation to show how this child was brought about? And then we also need documentation in relation to the citizenship, nationalities, immigration requirements, and so on and so forth. So if you like this, all these put together refer to the documentation requirements um, of surrogacy. And these are the things that as a lawyer, you who is practicing in this area, that you need to acquire the skill to identify the ones that you need, the ones that are relevant in the particular circumstance. And even when these documents are provided, you need to know what you're looking at, because quite often we are looking at documents that are generated by people who are not lawyers. You're looking at documents that are generated by doctors and surrogacy agencies and so on and so forth. And they have a very clinical focus, very narrow clinical focus. They're not looking at the things that we're looking for. So very often, as some of our colleagues who I've worked with who represent fertility clinics, sometimes I look at the documents and I quite frankly have to throw them out because they're not up to scratch. And the reason why I can say these documents are not okay is because I know exactly what I'm looking for. The other thing that your client needs you to do is to protect their interests. So your client might be an intending parent who has engaged in surrogacy or gamete donation or has a donor conceived child. Your client might be a surrogacy agency, an intending parent, a fertility clinic, a gamete transporter, somebody who is involved in moving gametes between clinics and between countries on behalf of clients, and so on and so forth. So their interests are the same. They need their interests to be protected. They need to be protected from liabilities or litigation, protected from exploitation or blackmail. And if there's intending parents, they always have a very, very serious premium on your ability to help them remove their surrogate born or donor conceived children from Nigeria with minimal delays. Now, if you're dealing with a corporate entity like a surrogacy agency or a fertility clinic, they would also need somebody to look at their internal and corporate governance structures to make sure that they are optimal. Now, a lot has been said about the fact that we do not have laws regulating surrogacy in Nigeria. That is true to an extent. We are operating surrogacy practice in Nigeria does operate largely in a legal lacuna. But if you had listened to my presentation yesterday, you would know that it is still touched by existing legislation, even though we do not yet have a dedicated and comprehensive legal framework for assisted reproductive technologies, including surrogacy. So the first thing I would say about serving clients in a legal lacuna would be you have to do your research. As lawyers, we are taught that we do research, but this is a particular area where you must do even more research than is expected in a more, what would I say, conventional or more popular practice areas. So research is a must. You have to understand exactly what you're doing. In a lot of times, we proceed by analogy. You liken what you're looking at to something that already exists. And this is something that we are trained to do as lawyers. We're taught in school about interpretation canons. The use them generis rule, the analogy rules, and all those other rules. So interpretation canons are your friends. Don't just regurgitate what other people are saying. You need to think. And the interesting thing about being in surrogacy practice is that there aren't so many people around. So you're forced to put on your thinking caps and think. And you can't just swallow and throw out something else something that somebody else because has already, something that is very well rehashed in law and practice. There aren't very many people here. It's a path not very well trodden. But the interesting part of it is that it forces you to think and not just repeat what other people say. I think one of the other things that I would say that has helped me a lot in my practice is taking a functional and not a formal approach to documentary and other legal requirements. So as has been said earlier on, I am dual qualified. I'm qualified in Nigeria as well as England and Wales. And very often, you're looking at the documentary and legal requirements from the UK or from some other country, because I do work with intending parents that come from other countries. And I'm looking at that legal requirement that is coming from the UK. Now, if I needed to satisfy that legal requirement in the UK, there would be certain documents that I would be able to use to satisfy those documentary requirements. But because the treatment is happening in Nigeria, I have to take a functional approach. So I'll be saying, okay, this legal requirement, for instance, if a legal requirement as to identity, if I wanted to prove somebody's identity in the UK, there are a number of documents that I could use that are not even passports. But a lot of those documents don't exist in Nigeria. But if I look at it, instead of throwing my hands up and saying, oh my goodness, those documents don't exist in Nigeria, I take a functional approach to that legal requirement. That legal requirement, for instance, requires me to establish with certainty and through the use of official and verifiable documents, a person's identity and a person's age. Now, there are documents in Nigeria which do just that. And so I would, for instance, I might pick up a national identity number, I might pick up a BVN document, I might pick up a permanent voter's card, and those things will achieve the same objective. And the reason why I can maneuver my way around it is because I'm not just looking at this requirements from a formal approach. I'm looking at it from a functional perspective. And I'm trying to see what exactly are these people trying to achieve and how can I help my client achieve that objective or meet that criteria with the documents that are available to us in Nigeria. And that's where you see having the advantage of being qualified in both countries. So I'm Nigerian, but I'm thinking about legal requirements that come from a different country. So you also need to do some forum shopping. Surrogacy is a very novel area. It's novel for the lawyers, it's novel for the judges, it's novel for the lawmakers. Everybody's encountering it for the very first time, and we're proceeding carefully and doing the best that we can with what is available. I know I shouldn't be saying this, but some judges have more experience of encountering these kind of cases, and so it's easier to get what you want. You don't need to say too much. They understand exactly where you're coming from. The judges are human beings. They are colored, they are formed, their opinions are shaped by their background. Some of them are liberal, some of them are conservative, some of them are come from different shades. And when I say liberal and conservative, I'm not talking about particular religions. You can have liberal and conservatives in any religion under the sun. But what I'm trying to say is in terms of understanding the way they are likely to approach your application. So I would always say that, I mean, and somebody's going to kill me for this, but don't just carry your application to just anywhere. Do a little bit of homework and find out who has been there before you and what was their experience. And then also, I have a lot of friends who are judges. They get bored too. They see the same old, same old, same old applications every day. Sometimes they need some excitement. They like to see something novel. They like to see something interesting. So if you do your homework, try and titillate them. Explain, educate, don't assume, don't talk down at them. Of course, we're trained not to respect judges. Take them along with you. And I find that quite a lot of them would call you aside and say, oh, counsel, can you provide more information or more material? I'd like to understand exactly where you're going with this particular application. I'm sure there are a few judges here, and I'm sure there are a few gossips here who will go and say that this is what Undiga said, but I haven't said anything wrong. I'm just saying the truth. So, surrogacy practice, what a lawyer needs. Of course, no surprises to say you need a knowledge of the law. And surrogacy practice sits at an intersection between a lot of different kinds of laws. So you have contract law, domestic and international. You have the fundamentals, the essentials of a contract, the covenants of the contract, conditions precedent. What would be the things? What are the breaches that would be considered fundamental that would scupper the contract? What are the vitiating factors that you should look at and be worried about from the point of at the point of formation of the contract? Of course, we have the law of evidence, particularly documentary evidence, because surrogacy, especially international surrogacy, is 98% a documentary game. So you need to know the rules about documentary evidence. Sometimes I see documents produced by some clinics and their lawyers, and I wonder if they've forgotten about their training. There's certain fundamental things about documentary evidence that must be at the tips of your fingers at all time. Because one thing you have to understand is that, especially in international surrogacy, these documents are going to be presented at international foreign missions, embassies, high commissions, and so on and so forth. They will go over these documents with a fine-tooth comb and a magnifying glass, and anything they don't like will be resolved in the disfavor of your client by the denial of the application that they're looking for. So you must be very careful. If you don't have an eye for detail, surrogacy practice is not for you. You really need to sit down with a cold eye, a cup of strong coffee, when your eyes are fresh and your brain is fresh, and go over those documents page by page, clause by clause, line by line, to make sure that everything is fine. You need a good knowledge of family law. Truth be told, fertility law is just a specialized area of family law, which deals with family formation through assisted means. That's kind of taken up and grown and developed a life of its own. But really, fertility law can be described also as advanced family law. You need a knowledge of Nigerian medical law, and people like Bebeniza Iguatu are experts in this area. You need also to have an idea of human trafficking legislation, because, as I said before, fertility law does have a high potential for exploitation, which will bring you in the crosshairs and bring NAPTIP into your business. In terms of, in addition to knowledge of the law, you also have other requirements and skills. We have negotiation and mediation skills. Disputes that have to do with surrogacy and fertility law, assisted reproduction, are really not suited for litigation and courts. So being able to, douse the fires, negotiate and mediate when things go wrong would be skills that will stand you in good stead. As a matter of fact, I recommend for anybody who's interested in fertility law to do some mediation training. You need a basic knowledge of psychology and counseling. Whether you like it or not, you'll be involved in counseling people. Sometimes you will have to put the law aside and talk to the person, because infertility and needing to go down the surrogacy route is not a walk in the park. In my practice, everybody knows in my office knows that every time I have a fertility consultation, that there must be a box of tissues somewhere in that office, where in that room where I'm having the meeting, and cold water and nuts and sweets, just to help people, calm down and face it, because it's not an easy thing to go through. You need a basic knowledge of biology and anatomy. You need to understand the fundamentals of infertility and reproductive medicine. So unfortunately, those of us who ran away from mathematics and biology, and because we didn't want like those subjects, we decided to study law. Maybe fertility law is not for you. Now, I'll say a few things about international surrogacy practice and what lawyers need. You need a keen eye for detail, for problem solving and thinking outside the box. In fact, what I tell my mentees is that nuke the box, obliterate the box. There is no box. There's just space for you to be creative and look for solutions to problems. And you have to do that because you're a lawyer. And if you can't do that, then you shouldn't have become a lawyer in the first place, because that's what we do as lawyers. We look at the rules, we look at the laws, and we come up with solutions, with legal solutions on behalf of our clients. Now, what else does a lawyer need to be able to engage in international surrogacy practice? You need to have an understanding of the conflict of laws, because when you have international surrogacy, you have an engagement between the legal systems of two different countries, their laws regarding nationality and citizenship, immigration, and so on. So you have one set of rules in the treatment country, which in my case would be Nigeria, and another set of rules which is from the destination country. And then sometimes those interactions between the rules of those two countries, they come up with some very unlikely and unpredictable results, which you need to understand as it relates to the particular clients that you're advising. You need to understand that the fertility laws of countries always, almost without exception, have extraterritorial effect. So for instance, if I'm advising a client from the UK, I know that UK law will apply to that surrogacy arrangement, even though that surrogacy treatment is happening in Nigeria. And that client will need to comply with UK laws to be able to take that child back to the UK after the child has been born in Nigeria. And the same thing happens to no matter which country they're coming from. If the client is coming from the US, from the state of Maryland, we will have to comply with Maryland law. You have to be careful with countries like the US that have a federal system, that where you have individual states have individual requirements. So when you say, oh, this person is coming from the US, you need to ask next, are they coming from California? Are they coming from Washington, D.C.? Are they coming from Texas? Are they coming from Maine? Are they coming from Minnesota? You need to identify and drill down which state they're coming from, and identify whether or not you will need a legal partner, another lawyer from that country, to guide what we're doing in Nigeria to make sure that that child can enter the US. You need to also have a solid knowledge of Nigerian fertility law, or what little that we have of it, especially regarding documentary evidence. You need to appreciate the legal and documentary requirements of the destination country. And like I've said, in international surrogacy, you need to have a very deep capacity for professional collaboration, because if those clients that you're serving are coming from another country, you don't know the laws of that country. You need to find a partner. You need to get a lawyer from that country, a fertility lawyer, not just any lawyer, to advise you and guide you as to what requirements you need to satisfy, and what documentation, how the documentation from Nigeria needs to be presented to enable that person remove that surrogate born or donor conceived child from Nigeria. And one other thing that you need to know is that when you get to the point where you are not sure of what you're doing, or where you don't know what you're doing, when you're out of your depth, you should be able to identify the limits of your knowledge and expertise and know when to ask for help. Don't proceed in ignorance. There's always help somewhere. There's always somebody you can ask. If you need help from somebody, get help from somebody, instead of going on in ignorance and bungling the case for your client, in which case they're not going to be very happy with you. So in terms of breaking it down and understanding the different stages, I would say that we have in a surrogacy, there are 3 stages of the lawyer's engagement or the lawyer's work. So you have the pre-contractual stage where no contracts are yet signed. The intending parents or whoever is consulting with you is trying to figure out what they need to do, how they need to go about it. You need to understand their specific circumstances. And at the end of the day, what they really want to know is, what do I need to do? How do I conduct the surrogacy in a way that at the end of the process, I'm able to take my child home or remove my child from the country with a minimal delay? I'm able to acquire parental rights over this child that has been born by a surrogate. So that's the pre-contractual stage. Then you have the contract stage where the documents have been produced and they now need to be signed by the different parties. The documents will either be they'll be drafted by either the hospital's lawyer, the intending parent's lawyer, or somebody else, and they will now collate the documents. They will be signed. Those of them that will need to be notarized will be notarized. So basically, at the execution stage, where we begin to execute documents and produce the documents, put the signatures, and so on and so forth. And then after that, ideally, is when the treatment starts. We have egg retrieval, embryo transfer, hopefully confirmation of pregnancy. The surrogate goes on and has the baby, and then the baby is born. And then we enter the next stage, which is the post-birth stage, which is a completely new different set of considerations which are triggered by the birth of the child. And then we begin to pick things up, begin to think about birth certificates, the documentation from the hospital, the reports, embryology documentation, and then think, and things ramp up really quickly, because at this stage the parents are anxious. Okay, the baby's been born. Oh yeah, oh yeah, oh yeah, oh yeah. We want to go. We want to go. We have leave. We just took leave for a certain period of time. We want to get going. And then all kinds of pressure is built, is mounted on the lawyers, because the clock is ticking. Sometimes that's the point at which the parents have come from abroad and they're like, I don't have time to waste. I don't have time to waste. And then you are, as a lawyer with conduct, will now need to start putting all these documents together to make sure that we move on to the next stage, which is to be able to apply for the necessary documents to enable the child leave Nigeria, if that's the case. So if we look at it in a little bit more detail, at the pre-contractual stage, what are we doing? Or what should we be doing? So at this stage, we need to identify the treatment plan. Remember that we had spoken about earlier on, we talked about different infertility factors. And we talked about the fact that the specific assisted reproductive technologies in use are deployed to overcome specific problems. So we talked about where a woman has a poor ovarian reserve, she has a problem with her ovaries, and so she cannot produce eggs. And so the assisted reproductive technology we'll be looking at will be egg donation. But in surrogacy, most of the time you have a uterine factor. Either that woman who's trying to have a child doesn't have a womb, or she has a medical condition which makes it difficult or impossible for her to carry a pregnancy. And I mentioned the example of fibroids, which is very common in our environment. And so we need to identify the treatment plan. So it is surrogacy, fine. Does it involve egg donation? Does it involve sperm donation? What are the legal requirements that have to do with that treatment plan? And when we say legal requirements, we talk about substantive and procedural legal requirements. What are the legal implications of them using, for instance, using a surrogate? Legal implications of using a surrogate is that we will now need to go through a process of terminating the surrogate's status as a legal mother and transferring it to the intending parents. We'll need to check whether she's married and other things. What are the legal implications? If it is donor sperm, if it's donor egg, how has that egg been sourced? How has that sperm been sourced? Has the right consent, have the right documents been generated, and so on? Then we're looking at the surrogacy type. We're thinking about how parental rights are acquired in that circumstance. We're looking at, after when you begin to look at the particular mix that is presented with that intending parent, what are the nationalities and citizenships engaged? Which destination country are we talking about? Is the child, are the intending parents, they come from the US, they come from the UK, Australia, or somewhere else? What are the legal requirements from that destination country that we need to bear in mind as we begin to try to establish how to advise this particular client? Then we begin to think about identifying foreign legal partners as well as the requirements. And then we now begin to think, okay, which fertility clinic has been chosen? Is there surrogacy involved? Are there other parties, for instance, like a gamete transporter? Are we expecting the eggs or the sperm of the embryos to be shipped in from abroad? What are the documents that need to be done? And other aspects of due diligence. All these things are the things that happen at the pre-contractual stage. Then we move to the contract stage. At this stage, we have drafted the documents, we have reviewed the documents, we have collated them from wherever they have come from. We are thinking about how the proper execution. When I say proper execution, I'm not just talking about the documents themselves. I'm talking about the procedures through which these documents are executed, because these are legal requirements from many of the countries that your clients will be coming from in international surrogacy. We're thinking about liaison with foreign lawyers, clinic surrogacy agents, and so on. That's the stage at which the documents have been identified, the treatment plan has been concluded, and then we're signing documents. And then ideally, you should be involved with the intending parents, although very often you will not be at this stage, checking these documents to make sure that everything is fine before they are signed. Because if not, more often than not, if your engagement comes after the documents have been signed, these documents might need to be redone because they are not suitable for the countries where these children are, where these intending parents live. And then the next stage is the post-birth stage. This is, of course, starts after the birth of the child. In the delivery room, it's very important to note that the only thing the surrogate can do in the delivery room is hand over custody of the child. She still remains the legal mother of the child, irrespective of what that birth certificate says. And I had explained yesterday the reasons why that is the position. So you have a lot to do with the surrogate's post-birth care, what is going to be happening with her, in terms of for how many more weeks after the birth you have the postnatal checks to make sure she gets them, to make sure that her financial compensation package that is triggered by the birth is satisfied. That's point to also begin to think about how we acquire parental rights. We think about filing for a parental order application both in Nigeria, and what we need to get together for that for when the child enters the destination country, when the parents are now in a position to begin to file for a parental order to acquire parental rights in the country where they're coming from. There's all these things to do with exit strategy implementation, which is basically how we get the child out of Nigeria. Are we looking at a visa application? Are we looking for a passport application? In addition, if the child is eligible for a Nigerian passport, the child might be eligible for the passport or the citizenship of the country where their parents or their intending parents live, or where they are destined to go and live with their parents. It might also require you to attend, to be physically present at the destination country, foreign missions, embassies, high commissions, etc. Sometimes they will ask to see you. Sometimes they'll ask to see the surrogate. Sometimes they will actually ask for the baby to be brought in physically and for the surrogate to be brought in physically into the high commission or the embassy. That will require your time. And you will also now begin to think about how the child, the surrogate born or donor conceived child, leaves Nigeria. And then very more often than not, people don't appreciate that when after the child has been born and custody has been of the child has been handed over to the intending parents, actually that's not where it ends, because more in most countries, the child has to enter the country where they intend to live with their parents, and there's some more processes that will happen thereafter. And more often than not, it's only after the child has entered that country that the parents will be able to apply for a parental order that makes them the legal parents of the child. And that parental order that they need in the destination country requires the involvement of the surrogate. So if you have structured the management plan in such a way that the surrogate is no longer available, you will have some trouble. So you need to understand the full extent of and the times or the full extent of the surrogate's involvement, and the fact that even after the birth, we still require her to respond to court papers and so on, and fill documents and so on. And she might be required to go into the embassies more than once. I've had cases where a child has left Nigeria and entered the UK or another country, and the court has made an order that the surrogate should attend in person at the foreign mission in Nigeria. And if you have not kept the right documentation, if you have not informed her that her involvement will be required, you might run into trouble trying to find her. And if you've given her all her money, it's basic human psychology. It's like, why are you bothering me? I've collected my money. Why are you people worrying me? Nobody told me that I will still be needed 5 months, 6 months after the birth. Well, I'm in Sokoto. If you want me to come, bring me some more money. And then people begin to look at the lawyer as if the lawyer is asking for something to put in their pocket that is not justified. So it needs to be ironed out and understood from the very beginning that this surrogate will be required, her attendance might be required, and until that parental order in the destination country has been gotten, the surrogate has not finished her work. So I'm sure you'll be very interested in this particular aspect of my presentation about billing, getting paid for your work. I remember when I was in law school, I think her name was Mrs. Doherty, I think of blessed memory, was the one who taught us about law office management. And I wish I'd paid a bit more attention when she was lecturing us then, when she talked about scoping your work. It is critical. Sometimes it is difficult to understand from the very beginning the exact scope of the work, how much work is required. But at least 70%, 80%, you should be able to anticipate how much work will be required from you and how much time. But I must say from the get-go that surrogacy is an area where sometimes it turns up a lot of surprises. I give you an example. Late last year, I had a couple of clients who came to me and who I was doing some work for, and I made the mistake of not insisting that there was a surrogacy agency involved. And why did I say I made the mistake? These were intending parents that lived outside Nigeria and who had planned their time so that they would arrive in Nigeria just before the birth of the child. Now, what happened? The surrogates went into premature labor. And what else happened? The people who were designated on the paperwork as being the guardians, for one reason or the other, refused to take their calls, refused to answer their phones. And so the hospital was in panic, called me because I was the next person whose details were on the documentation. And they called me and said, Barrister, I'm like, hello. They said, this is so and so clinic, Abuja. I'm like, well, yes, what do you want? They said, your surrogate has gone into premature labor and we are thinking about a cesarean section and we need somebody to sign consent forms and we need somebody to take custody of the child at birth. And this was me struggling, jumping out of my bed, rushing to wash my face, brush my teeth so I won't kill somebody with bad odor at 2 a.m. in the morning. Luckily, my driver was around, jumping into my car and rushing up to the clinic to go and sign consent forms because intending parents were not around. Sorry, the guardian was not around. To sign consent forms and to take custody of this child at birth. And the earliest my intending parents could make was 3 days after the birth because they were coming from Australia. So this is something that if I had thought very carefully about, I should have included in my scope of work. But then again, you ask yourself the question, how much would you be paid to jump out of your bed at 2 a.m. in the morning and dash halfway across town to go and take a delivery from a surrogate that went into premature labor? I just make this example to give you an idea of how sometimes it can be difficult to scope the work. So another thing about billing is focusing on outcomes, not processes. Your clients are not interested in your processes. Your clients are interested in the benefits, the outcomes that it provides to them. So if you focus on the outcomes and then the processes are steps which help you to achieve the outcomes, then it will give you a slightly clearer idea and a head start on how to scope your work and begin to put time and money on what you're doing. And I think one of the important things that I have learned by being in an area that is new is that you really, really need to learn how to communicate the value of your work to your clients. Your clients, in many cases, they don't really understand why they need you. They don't really understand what you do. In fact, some of them are coming to you and people are telling them, I don't know why you're wasting your time talking to this lawyer. You don't need a lawyer. Just tell the clinic to put your name on the birth certificate and you'll be fine. So you really need to understand how to communicate the value of your work. Like if, for instance, you're working in conveyancing and in land transactions, almost everybody knows the benefits of consulting a lawyer and getting legal advice because they have seen examples of what happens when people don't involve lawyers. But because people don't really talk very openly about surrogacy, it's a bit more difficult for an intending parent to understand why you're telling them that why they need a parental order and why all these documents are important to make sure that they are done correctly and so on. But I think the slight advantage you have with intending parents who come from abroad in international surrogacy is that they know that the embassies and the high commissions, they don't play with their documents. And if the documents are not done properly, they won't be able to take the child out of the country. So I always say that in international surrogacy, the litmus test, the real test of whether you've done a good job is whether or not your clients are able to take their children out of the country with minimal delays. You're cutting back on the number of times you put in an application and the embassy sends it back with a query or a refusal because something wasn't done properly. I think that's the litmus test. When the children are not being taken out of the country, it can be a bit difficult to communicate the value of what you've done to the intending parents. But I always tell them that nobody knows the value of doing things properly until there's a problem. And then everybody begins to say, had I known. Yes, I'm a great believer in not reinventing the wheel and standing on the shoulders of giants. Now, this lady is called Nkem Okoye. If you are a young lawyer and you're not yet a silk and you're really interested in advancing your legal practice, you should know this lady. Now, she'll be thoroughly embarrassed. She didn't ask me, she didn't pay me. I haven't spoken to her. I'm ashamed to admit I'm supposed to be her student. I really should be listening to her and speaking to her more often. But if you listen, if you follow the work that Nkem Okoye and some other people do, you will begin to understand a little bit more about legal marketing, about communicating the value of your work, and how to attract the right clients. Now, I've given you a little summary of some of the things that I've learned from her, but I must say that if you go and listen to what Nkem Okoye has to tell you, you'll find out that I'm a very terrible teacher because she knows exactly what she's talking about. This is a classic example of what Nigerians say, follow who know road. Look for Nkem Okoye. She's on Instagram, she's on LinkedIn, and find out what she does. I think she's also based in Abuja. Go and tell her that Undiga asked you to harass her and for her to teach you what she knows. It will be one of the best things you do in 2025 for your legal practice. Now, let's think billing. We have the Legal Practitioners Remuneration Order of 2023. How does it help us when we're thinking about billing in surrogacy practice? Now, one thing I have to say about that order is that the order is about establishing floors, not ceilings. Basically, the objective of the order was to create a framework that would allow legal practitioners charge fairly and authoritatively for their work by making it impossible or difficult for them to charge below a certain threshold. And that's what I mean when I say that the order is about establishing floors, not ceiling. The order is not about capping your ability to charge your clients. It's about establishing a minimum standard that will allow legal practitioners earn a reasonable living livelihood from the work that they do. So it's not about capping, it's about establishing minimum standards and being able to bring out a piece of legislation and use that to force your clients to respect and compensate you for the work that you do. So it's about the protection of the livelihood of lawyers. And it establishes some very important and useful guiding principles that are based on geographical location. Of course, it costs more to live in some parts of Nigeria than the other. It also establishes some guidelines based on your age at the bar and your experience. But I must point out that your age and the bar at the bar and your experience is used as a proxy for the expertise that you bring to the job. And I hasten to add that there's a caveat. I'm not saying this because I am trying to how will I say um, bring older practitioners like myself. I'm 25 years at the bar. I'm not casting shade on, casting aspersions on people who are older at the bar. But the point I'm trying to make is that the expertise that you have is not always a function of the number of years you have spent at the bar. And I'll say that again. The expertise, the level of expertise you have may not necessarily be directly determined by the number of years you have spent at the bar. And I give you an example. I took a career break from the legal profession when I was doing my PhD. I wasn't in legal practice. What that meant is that even though I am 20 something years at the bar, if I take out the number of years I wasn't in legal practice, it means that people who are younger than me at the bar probably who have been in active practice, they have a heads up on me. They have an advantage. So your age at the bar and your experience is used as a proxy for your expertise, but it's not the final determinant of how much you know. And I give an example. Surrogacy law is a new area of the law. And sometimes I sit down with some silks and I lecture them because it's something that they don't really know much about. But there will be other areas where I sit down and I have my younger colleagues lecture me about the new CAMA and lecture me about other areas of the law. So what am I trying to say? The fact your age at the bar is not necessarily a barrier for you to develop expertise. If you take out the time to develop your expertise, you will sit down with elders and lecture them. That's the bottom line of what I'm trying to say. Now, the order also talks about exclusions and exclusions. It excludes pro bono work, etc., etc. So the order is comprehensive, but not conclusive. It's not far reach. It doesn't cover everything. And so it has section 2, which I call the catch-all provision, which gives you some guidance about what to do when the particular type of work that you're thinking about is not mentioned specifically in the order. And it sets the principles that can be used to estimate, to guide you about how to cost or put a price or value the work that you're doing in that particular area. So you have in section 2, the complexity, the difficulty, and the novelty that is implicated in the work that you're doing. And I highlighted novelty because surrogacy practice is still a novel area of practice in Nigeria. Section 2 also talks about the amount of skill, the labor, the experience, the specialized knowledge and responsibility that is involved in the work that you're doing. It talks about the number, the diversity, the technicality, the importance of the documents that need to be prepared by you or perused or reviewed by you on behalf of your clients. And I said earlier on that surrogacy is a document-heavy area of practice. It talks about the time expended to do the work, the turnaround time, the amount of money of value that is implicated in the work that you're doing. Now, the question you ask yourself is, if somebody has gone for 10 years, 12 years, 17 years without a child, and they have spent millions of naira on surrogacy to finally have a child, and you are the one who is handling the documentation to help that person finally remove that child from Nigeria, how do you value your work? But on the flip side, are we supposed to be considering a transaction that involves a child, a life, in the same commercial terms as we consider a transaction for land or property or houses or other kinds of things that may be the subject matter of a contract? So there's a fine balance that needs to be struck there. And then, of course, we think about the importance attached to the business. Can there be any business that is more important than somebody finally being able to become a parent and take their child home? But these, I just put this out there as examples of ways in which you can begin to think about section 2 of the remuneration order to give you guidance about how to charge, how to bill for the work that you do. So the question I think at this stage we ask ourselves is, what is your work worth? And for me, these 3 circles or parameters jump out at me very strongly when it comes to surrogacy. The novelty of the work. Whether you like it or not, a lot of people who are attending this webinar because of the novelty. It's a new area. Oh, wow. this is something that's been happening. Maybe if I jump in here, the field won't be too crowded. I probably will be able to, carve a niche for myself. Unlike election petitions where all the SANs have commandeered it for themselves, and other areas of law, maritime and so on and so forth. Okay, is this an area where I can establish a niche for myself pretty quickly because there are not very many people involved? That's the novelty. The expertise and the specialized knowledge. Is it something that takes time to acquire the knowledge to do? Is it something that anybody can acquire the expertise and the knowledge to do? Is it, or is it a specialized, a niche area that requires considerable investment of time and effort and money and travel and other things to be able to acquire the expertise to do it? So these are factors that would affect your billing, your ability to bill, your ability to command a higher price for your services. And then, of course, you're thinking about the complexity and the diversity of documentation. I always say that surrogacy involves a lot of documents, some very important documents, which are quite complex and which are quite diverse. We have several different documents that we need to put together when we are doing surrogacy, especially in an international context. So if you put all those things together, you consider all those factors, then you begin to ask yourself, how much is my work worth? So if you look at Section 2 of the Legal Practitioners Remuneration Order of 2023, the question which I'd like us to talk about after I've finished speaking is, how do you think surrogacy legal work ranks according to Section 2 of the order? Where do you think surrogacy work ranks in terms of the parameters I talked about from Section 2? Novelty, expertise, specialized knowledge, complexity / diversity of documentation. Where do you think, or how do you think surrogacy legal work ranks according to Section 2 in terms of how we bill, because the way you bill for your work is directly correlated with the value which you think you bring to your client. If you think your work is worthless, you will bill accordingly. And your client will have a perception that your work is not very valuable. And that was why I went back and I said that it's very important. I find the work that Nkemukoye does very, very important about legal marketing, how your services are packaged, how you communicate the value of your work. So even before the first step before you communicate the value of your work is that you yourself have to have a deep understanding and appreciation of the value of the work that you do. So your work needs to be carefully organized and packaged. You yourself need to understand what you're bringing to the table, and then you'll be in a position, it's a psychological thing. You're only able to give what you have, and you'll be able to communicate the value of your work. Now, if you don't value your work, it affects the way you communicate, it affects the way you market, and it will affect your ability to attract the right kind of clients. And at the end of the day, the money that you make. So you have to take a look at yourself and ask yourself, do I have the necessary expertise, the specialized knowledge in order to situate yourself in this very novel and exciting new area of the law, which will require you to put together and be able to manipulate a complex and diverse amount of documentation to be able to serve your clients. So the question is, are you there? And if you're not there, how do you get there? And how do you begin to put together your legal service packages in a way that will attract the right kind of clients, that will allow you to build to the level of your expertise and allow you grow in an area where there is obviously a lot of scope and a lot of opportunity for growth. So this is a question that I'm even myself as a practitioner, I tell myself that the biggest room in the house is the room for improvement. No matter where I am, there's always room to grow. And this is something that we all have something to learn about in terms of how we value our work and how we allow the way we position ourselves in a way that our expertise allows us to command higher billing levels. So in terms of summary, I would say that surrogacy practice is interesting and novel, but be prepared to be stretched. Don't be fooled, it's not as unregulated as you think. Yes, we don't yet have a dedicated regulatory framework for surrogacy, but however, the practice is affected by existing laws. And if you have, sorry? And if you have clients or intending parents who come from abroad, you will need to expand your knowledge to include a deep appreciation of the international dimension, the fertility laws in force in the countries where your patients, your clients are taking their children to. I also cannot finish this presentation without saying something about being aware of pitfalls. Surrogacy has a very high potential for exploitation, and I'll explain why. We all know when we're in year one, year two, wherever you learn to, we were taught about the fundamentals about the law of contract, about party autonomy, about unequal. We were taught particularly about unequal bargaining power and vitiating factors like duress and so on and so forth. Every time you sign a surrogacy contract, every time you're involved in a surrogacy contract, I want you to be aware that those things are at play. We said at the beginning of my presentation, I spoke about the context of surrogacy in Nigeria and the fact that we have high levels of poverty. Whether we like it or not, the vast majority of the people who volunteer to be surrogates in Nigeria are motivated by poverty. So if you have a situation where a woman considers that the money that she's going to make through a surrogacy, because of where her situation, she considers that kind of money life-changing. Yes, the money that some surrogates make can be life-changing. It can be life-changing, can quite literally be life-changing for some people. But I remember that when we say money is life-changing, the amount of money that is life-changing for me might not necessarily be the kind of money that's life-changing for a man like Dangote. So it depends on context. So you have somebody who is so poor that they are willing to sacrifice 9 months, if not more, of their life to subject themselves to fertility treatment at the instance of somebody else, to carry a pregnancy with all the pains. Women among us and people who have been close to people who are pregnant know that pregnancy is not a walk in the park, and somebody chooses to do that for somebody else. The question we have to ask ourselves is that person really in a position to negotiate? I don't think so. I think it's a classic case of unequal bargaining. I think that the surrogacy contracts, especially surrogacy contracts in places like Nigeria, are classic examples of where you have unequal bargaining power at play. And so as a legal practitioner, you have to be aware of that. I personally have certain limits, certain standards. If the particular compensation package for a surrogacy is below a certain threshold, I will not be involved because I think it's exploitative. You also have to be aware of the fact that even though surrogacy is not specifically mentioned in our laws, the NAPTIP Act, the National Agency for Prevention of Trafficking and Exploitation of Human Beings, NAPTIPs or something like this, it has a catch-all phrase in their jurisdiction clause, which empowers them to take care of any aspects of human exploitation and coercion. And it is because of that particular clause in their interpretation section of the act, that is why you find NAPTIP involved a lot of times in surrogacy cases and baby fracture cases and so on, because there are some people, unfortunately, who would not blink and would not hesitate to exploit a surrogate and pay her peanuts because she is willing to do what is required to help them have a child. So I think that we've always been taught that as lawyers, we take the moral high ground. We are officers in the temple of justice. And I think that if a lawyer is involved in a surrogacy agreement where the package is not suitable, I think the lawyer should be bold enough to say that I don't think this is good. I don't think this is a fair deal, because um, it does not compensate the surrogate adequately. But then again, you also have to bear in mind that I'm not sure that there's anything like compensating the surrogate too much for helping somebody to have a child. But that is a discussion for the ethics, not for, but right now we're talking about the transactional point of view, because I worry. I haven't yet seen very many examples which have arrived in court. But I think that it is not a very good thing for a legal practitioner to be involved in a surrogacy agreement that is exploitative in any way. I think that you should also look beyond the point of the idea that you have the immediate needs of your client, which might be a clinic, which might be an intending parent. I think you also have to think about the general interest of justice and the interest of the society in the prevention of exploitation of people. Because whether we like it or not, surrogacy does engage raise some very serious ethical issues, which we need to be aware of as legal practitioners. So I would say that if you're interested in going into surrogacy, please be aware of these ethical pitfalls, the pitfalls in surrogacy. Another pitfall you should also be aware of is that some intending parents and some clinics indulge in all kinds of fraud, fertility frauds. So I know people think that, oh, paternity frauds. Yes, there are paternity frauds and maternity frauds that are perpetrated by clinics. And there are also paternity frauds and maternity frauds that are perpetrated by spouses against each other. And sometimes they will approach you as a lawyer to help them cover them up. I give you an example. Somebody approached me once and asked me to hide from her husband the fact that she was using a donor egg. She didn't want her husband to know that she was using a donor egg. She wanted her husband to go ahead thinking that it was her egg that was used. I've also had cases where husbands have approached me and asked me to hide from their wives the fact that they are using a donor sperm. I've also had husbands who have approached me and asked me to hide from their wives the fact that they wanted to use their mistresses or girlfriends' eggs for the IVF treatment, or to use their mistress or their girlfriend as their surrogate. So I'm pointing this out because these are some of the very unsavory aspects of surrogacy that people don't really talk about, that you need to be on your guard for. You must ask questions. Ask questions. Where's the egg coming from? Where's the sperm coming from? Who is the surrogate? Who recruited her? Who screened her? Where is her ID? Where's her proof of ID? Where is her address? It's within your rights to ask to see that surrogate. And if you have a whiff of anything that's inappropriate, my recommendation would be to leave it. Tell them that they either come clean, come above board, and you satisfy yourself that what is going on there is ethical, or you step out. I don't think you should be so desperate that you get involved with some unsavory practices, because honestly, when NAPTIP becomes involved, they pack everybody. Once they see that you're involved, and the fact that you're a lawyer will not necessarily save you, because if in the process of the investigation, NAPTIP or the police find out that you're involved in some kind of shady deals, the fact that you're a lawyer will put you even inside more trouble. And I don't think any client has enough money to pay me to put my license and put my credibility on the line just because they want to hoodwink their spouse or hoodwink their wife or their husband. So I'd like to end by saying that there's a lot to learn, but the rewards are more than worth the pain. Thank you for listening, and I look forward to entertaining your questions and your observations. Thank you. And I don't think any client has enough.
Thank you. Please, can anyone hear me?
Yes, I can. Ebenezer, I can hear you.
Oh, thank you. Thank you very much. Thank you very much. Dear participants, please, can you help me celebrate our facilitator? Please, please, please. Please let the applauses come in, let the thank you come in, let the we love you come in, let the encomiums come in. You will all agree with me that this is a master class, and if participants paid $1,000 for this 2-day session, it wouldn't be too much a fee to pay to gain this knowledge. What we try to do at the Medical and Health Law Committee is to feature on our platform as facilitators persons with practical experience. If you have followed this class since yesterday and today, you will agree that these are not theoretical knowledge. It is not what you read up in textbook and come and do slide presentation. No, it is many years of experience. Madam Mundiga, we cannot thank you enough. From all of us at the entire Garki branch, including the Medical Law Committee and the entirety of the branch, we thank you for your magnanimity, for accepting us and taking up this function. Ladies and gentlemen, we'll go quickly into our question and answer segment. If you have your questions, kindly put them up on the chat box. We will read it out. I will read it out, and we'll have the question attended to by our facilitator. Let's do that possibly in the next 10-15 minutes. Let's do that possibly in the next 10-15 minutes. Any questions? Kindly put them up. Thank you. Any questions, please? Okay, we are having appreciations. Well done, ma. Okay, someone says, okay, well done, ma. We appreciate you for the lecture. Thank you. That's Joan Marcin. There's a question here. Okpanachi Henry is asking, what are the documents needed for international surrogacy? What are the documents needed for international surrogacy? That's a question from Okpanachi. Then we have John Bose says, what price will be considered reasonable and not exploitative in the circumstance? You have not told us the particular circumstance. But I want to believe one of the scenarios she painted. So we have two questions. Keep the questions coming in, please. What price would be considered reasonable and not exploitative in the circumstance for the surrogates? Okay. Then, please, what are the legal requirements of a surrogacy agency? Okay, so we have three questions on ground now. Maybe we will be taking these three while others come in, please. Question one, again, what are the documents needed for international surrogacy? Then, two, what price would be considered reasonable and not exploitative in the circumstance for the surrogates? Three, please, what are the legal requirements of a surrogacy agency?
Okay. Sorry, in case I forget, let's just take it one after the other. Now, I think the last one you said, what are the requirements for a surrogacy agency? Now,
Yes.
remember that we do not yet have legislation about surrogacy agencies, what a surrogacy agency is, what the required prerequisites are. But what has been happening is that the CAC has been treating surrogacy agencies somehow like nursing agencies. So most of the time, more often than not, they will require that you have a doctor on your board or as one of the directors of the company, and then they will have all the other requirements. However, Lagos State is in the process of creating some guidelines which will be applicable to surrogacy agencies. So that's what I can say about those. The other question you said, what amount would be considered, what level of compensation for the surrogate be considered suitable and not exploitative? Well, my view is this. Nobody can put a price on a child. On the other hand, there are serious ethical concerns about making surrogacy freely a laissez-faire affair, in which case it is going to the highest bidder. But when you're looking at the surrogate compensation package, it includes a lot of elements. There are some parts that have to do with clothing, monthly payments, accommodation, medical care, and then you also have the cash payments, which usually come, the bulk of the cash payments come at the end of the process. So I think, to my mind, at the risk of making it look like surrogacy is something that should only be available to rich people, and also bearing in mind the fact that the surrogate herself enjoys party autonomy. If I say, for instance, that a package of 3 million naira was what I would consider my baseline, there would be some surrogates that would say that 3 million naira is too much for me. If you put a package together of 1 point something million or 2 million, I'll be willing to accept it. So, and I'm saying this because this is something that I've experienced. Sometimes I've advocated for a higher level of compensation, and the surrogates have come back to attack me to say I want to spoil their business. But I think that if you look at everything put together, any surrogacy package that is less than, is difficult to say, in the region of about 2 million naira, I would consider that exploitative in present day Nigeria.
Thank you very much, Ma. Thank you. Okay, we have more questions pouring in. For me, Chugo, I think your question is more of a consultation that requires you pay consultation fee to the facilitator, and you pay a commission to the Medical and Health Law Committee for putting up this webinar. Her question reads us: I have a couple in Germany that is considering coming to Nigeria for surrogacy to take the child back to Germany with them. Unfortunately, German government is against surrogacy in their country. Please, what will your advice be to this couple? Should they disclose to the German government? Sorry, I'm having some problem here. Should they disclose to them, or conceal that part that it is surrogacy? The question: this couple wants to come into Nigeria and have surrogacy done, take the child back to Germany, but German government is against surrogacy. The question is, should the couple disclose to the German government that the child is a product of surrogacy, or they should conceal that fact to the government? That's the question.
I said earlier on that in international surrogacy, there's an engagement between the legal systems of two countries. You have the destination country, the country where the intending parents intend to raise their children, where they're coming from. And then you have the treatment country, which is Nigeria. And to a great extent, it is the destination country that determines a lot of the things that we do. So in that case, I can't overemphasize. If you are a Nigerian trained and qualified lawyer, you are only qualified and trained to advise on Nigerian law. You don't have the requisite knowledge to advise on German law. I cannot tell a couple coming from Germany that this is what you need to do in order to get your child into Germany, because I'm not qualified to advise on German law. So the simple answer is they need to get a German lawyer. And if, as a Nigerian lawyer, you advise them and you make a mistake, on your head lies whatever the consequences of what you do. Because if there are consequences and on that the results don't pan out the way they want it, the intending parents will come back and blame you. And you don't have a leg to stand on, really. Like, I have practice rights in Nigeria and England and Wales. And once an intending parent is not coming from the UK, I will always tell you, go and get a lawyer from that country to advise you. I'm not going to stick my neck out. That's outside my expertise. We always have to learn to know when we've reached the end of our knowledge and expertise and not go any further. Very important.
Thank you very much. We have a question from Adiola. What steps do a counsel or should a counsel take when a spouse wants some things hidden from his or her partner? What happens to client's confidentiality?
It's an interesting question which comes up a lot. This is my point. This is my approach. A man and a woman enter into a marriage where they agree to share the rest of their life. And somewhere along the line, they run into trouble and they cannot have children the natural way. And they need to do so by assisted means. So even though they are two individuals in a marriage, they are still individuals for the purposes of the assessment of consent and for the things as such as crime and fraud. So the question I always ask, and I always like to make it personal, if your sister was married, because when you make it personal, it's very clear what needs to be done. If your sister was married and your sister's husband decided to use his girlfriend's egg or to use his girlfriend as a surrogate, if you found out about it, would you be happy? If your sister's husband was sterile and he didn't have any sperm and he decided to use a donor sperm, or maybe his brother's sperm or his friend's sperm, and your sister was supposed to carry the pregnancy without knowing that the pregnancy that she's carrying is not her husband's pregnancy. And somewhere down the line, a DNA test is done and it shows that that child is not her husband's child. How would you feel on behalf of your sister? See, sometimes when we make these theoretical questions, it's very easy for us to say, oh, it's fine. Oh, it's not okay. But when you make it personal, make that person involved in that story your sister or your brother. And it becomes very clear to everybody what the right thing to do is. I've come across many cases of fertility frauds. I can't tell you that the men do more or that the women do more. They are equally culpable. Women try to defraud their husbands. Husbands try to defraud their wives. Clinics collude with husbands and wives to defraud their partners. It's wrong. I have a case where a man used a donor sperm unknown to his wife, and a clinic colluded with him. And the clinic was saying that they justified their actions on the basis of patient confidentiality. Now, after the child was born, they decided that they wanted to japa. They did a DNA test, and the child failed the DNA test. The husband was in the forefront with his family to accuse his wife of adultery because he had not told anybody that there was a surrogacy, that there was IVF treatment, or that there was gamete donation. And I had to get involved, and I brought in the police. And we sealed the clinic and forced the clinic to confess that they had colluded with him. So you see, sometimes people take a very short view about things. Nobody knows what will happen in the future. Today, you're talking to an intending parent and they are fully sold on Nigeria. They are patriots. Come 2 years or 3 years down the line, Nigeria has happened to them and they want to japa. And all those documents which they did not want to collect, they now become important. Then they start scrambling, looking for you. And then you get implicated in the mess. So I always think that do the right thing from the get-go. Do the right thing from the get-go. And if you are not sure, stay out.
Wow. Someone said excellent exposition. This one is explosive. Oh. Thank you very much. Thank you. There's another question here. We might just take 3 more and we'll call it a day. For someone who desires to achieve a surrogacy but lacks an understanding of what it entails. How do such a person find a balance between understanding the ethics involved vis-a-vis financial implications of all aspects of the practice? That's the question of the person. Hannah Umaru.
Well, the truth is, surrogacy, IVF, assisted reproduction is expensive. Don't get it twisted. It's not cheap. If a fertility clinic or whatever provider is offering you a cycle that is less than 700, 800,000, I would doubt that that is what they are actually doing. It might be a baby factory pretending to be a fertility clinic. Surrogacy is expensive, one. Two, if it was you and you were to carry a pregnancy for somebody, how much would you charge? This is a human being we're talking about who is deploying using her body, which is highly contentious, to gestate a baby on your behalf. You don't pay her peanuts. There are risks. So, first of all, you have to acknowledge that if you don't have the money, forget it. Go and think about some other way. Maybe you need to think about adoption. But surrogacy is expensive. And the reason why most people go for surrogacy is because for them, they cannot compromise the fact that the child will not be related to them genetically. So very often, they want to use their own egg. They want to use their own sperm. And a lot of people will not do surrogacy if adoption was easier to do. Adoption is ridiculously hard in almost every state of Nigeria. It's so difficult. I remember I can't remember the professor, I can't remember the last vice president of Nigeria who was a law professor. I've forgotten his name.
Oshibanjo.
Oshibanjo made a commitment at some point that he would work towards making adoption easier. I'm not sure they did a lot of work in that direction. I was really looking forward to it because there are so many children who are there in the orphanages who are looking for loving forever homes. But the process is so fraught with complexity and difficulty that a lot of people just get frustrated and they forget about it, which is sad. So anybody who's thinking about surrogacy, Omo, go and prepare. Hold your money, count them well. It's expensive. And there are some people who have serious ethical objections about surrogacy. They feel that surrogacy is another example where rich people prey on the poor. And it's a valid argument. And I'll be the first person to put up my hand and acknowledge the ethical difficulties. I make money when people do surrogacies, but there are problems. There are ethical problems with surrogacy, which are not completely, they're not things that can be completely handled within the ambit of the law, which are concerns about commodification. Are we really is the ability to gestate a child, is this something that is supposed to be the subject matter of a contract? Are we doing the right thing? Some people, I'm surprised that nobody has come at me with Section 30 and Section 54 of the Child Rights Act, which says that we are not allowed to sell babies and deal in babies. When we're doing surrogacy, we have to ask ourselves the questions. Are we selling babies? Are we brokering the selling of babies, the exchange of babies? Are we trading babies? Okay, if we are not trading babies, what are the safeguards that we need to put into place to separate what we do as surrogacy practitioners from those who are operating baby factories and who are trafficking children? These are very important questions that we need to address. So I would say that surrogacy is not for everyone. And if you say that your moral compass would not allow you do surrogacy, fine. If you say that your ethical or your religious beliefs would not allow you to engage in surrogacy, that is fine, to each his own. But what I'm saying is that if we must have surrogacy practice in Nigeria, it has to have a certain minimum protective and safeguarding content. Otherwise, we are doing something that is highly problematic.
Thank you very much. There is this interesting question here. What happens to the expenses on the surrogates in case of a stillbirth?
The surrogacy contract must anticipate and make stipulations of what will happen in certain if the pregnancy does not end in a live birth. Even a woman who is carrying a naturally conceived child will sometimes experience pregnancy loss, or what we call commonly miscarriage. When it is a contract, when a contract has been entered into by the intending parents and the surrogate for the pregnancy, that contract has to anticipate what level of compensation that surrogate should be entitled to if it does not end in a live birth. So the contract should say, as long as the surrogate is not found to be negligent, she didn't go skiing, she didn't go bungee jumping, she didn't go dancing all night in the nightclub. She was doing the normal things that a woman who wanted to keep a pregnancy would do. And then, unfortunately, the pregnancy was lost. There was a miscarriage. You should say, if the pregnancy loss happens within the first trimester, this is a percentage of the final amount that she should be entitled to. If it happens in the second trimester, and so on and so forth. So the fundamental principle is what I think, what's it called? Quantum merit.
Yeah.
The surrogate should be compensated for the level of performance that she had achieved prior to the pregnancy loss. So that's the bottom line, really.
Awesome. Thank you very much, Ma. Okay, before I take the next question, which might be last, let me just say that I agree adoption is difficult, but that is one of the areas I play in. So this statement is coming based on a comment I saw on the comment section. Someone saying adoption is a no-no, it's a no-go area. Yes, some of us are playing in that field. I do adoption. In fact, in the month of June last year, I got 3 adoption orders for one family. The family wanted to adopt 3 children, and I navigated that successfully. So I do adoption within FCT, though you should know that adoption is jurisdiction specific. So that is one of the major challenges we have in adoption. Our final question is, what are the documents needed for international surrogacy?
Well, in international surrogacy, one, it depends on the country, it depends on the destination country, the country where the children are going, or the donor conceived child or the surrogate born child is going. It depends on the nationalities and the citizenships involved. It depends on the treatment plan. Does it involve gamete donation? Does it or not? It depends on whether the intending parents are citizens of that country or not. If they're subject to immigration control, what kind of immigration control are they subject to? Is it, like, for instance, in the UK, is it indefinite leave? Is it work permit? Is it course, certificate of sponsorship? There are a lot of variables. And it is the documents that are required depend on the facts of the case. But there are certain documents that are always standard, that are required in each and every case of surrogacy. One set of documents regards the treatment plan, the documents relating to where the treatment was done, which egg was used, which sperm was used, the process through which those eggs and sperm were procured, if there was a surrogate involved, who recruited the surrogate, the identity of the surrogate, her marital status, due diligence, etc., etc. If there was a surrogacy agency involved, the documentation requiring and reporting how the involvement of the surrogacy agency, the antenatal provider who took delivery of the child, who took care of the woman, all her antenatal reports, her embryology reports, and so on and so forth, that basically tell a story of where did this child come from. Remember, you have to have at the back of your mind that Nigeria is considered a place where people buy and sell people, talk less of babies. So if somebody leaves their home country where you have world-class healthcare and comes to Nigeria, the first suspicion the person at the embassy has is that they don't come again, no, they don't go buy picking for Nigeria. So the documentation has to state very clearly that, look, this is a legitimate case of surrogacy, and this is the process through which this child was brought into this world, and these are the people who are responsible for bringing this child into this world, and these are the documents which show that they are eligible to take this child back to the country that they're coming from. I like to put it out here before somebody asks me, I don't give lists, surrogacy documentation lists, to practitioners. Please don't be offended if you ask me and I refuse. Yeah. And it's for a simple reason. It's cost me a lot of time, effort, money, pain, sleepless nights to develop myself where I am at the moment. And these lists are my intellectual property. They are lists that I've developed over time and practice, tried methods, failed, tried again, and succeeded. So it's nothing personal. I'm not a charity. I intend to earn a living from doing this work. So please don't be offended when you ask me for lists for how I do my work. It makes me feel like you don't take my work seriously and you don't value my work. And I value my work. I try to value my work. And I'm sure as a fellow professional, you will understand that why I value my work because I put a lot into it and it's cost me a lot of money. I'm open to collaborations. I actually collaborate with Ebenezer and a number of other people. When I get to certain aspects of practice that I don't understand or I don't know a lot about, I actually farm it out to other professionals. But that said, I like to share my knowledge and please forgive me, but I have been planning to put together some kind of training program. A lot of people have approached me for mentorships. I've been in mentorships, certain mentorships that didn't work in my favor. And I'm very sensitive to make sure that if I call you my mentee, I should give you value for money. For even if you're not paying me for it, you should get something from me. And you should be able to say a couple of years down the line that, oh, I was Undiga's mentee and I learned something. So please be patient with me. I will, within the course of over the course of this year, God giving me strength and life, and put together a mentorship program and also a training program where I sit down and systematically teach people what I know and teach people the methods that I have used that work. Um, I'm not, I hasten to add that I'm not proud or something like that. But if you look at my profile, I spent a lot of money that can buy houses, training myself to get to where I am. And I must say also that I must commend people like Nkem Okoye and Chinwe Okonkwo, the principal partner of Riverbrook Solicitors London, where I actually went for 3 years as an unpaid intern to learn legal practice and where I encountered fertility law. That was time that I spent trying to train myself. I think sometimes people take it for granted that, oh, you know it, teach me. It doesn't always work that way. There has to be a price that you pay to acquire something that is valuable. So please, don't be offended if you come into my DMs or send me messages and ask me for lists. I'm likely not to respond, and this is my reason. So please bear with me.
Thank you very much. And on this high note, we want to once again, even though it will never be enough, thank our facilitator for pouring out herself. That's actually what she has done here. She emptied herself. Like I said a short while ago, if we paid $1,000 for this session, 2 day session, it will not be too much money because once you venture into the practice, this is knowledge you will never lose. You can only get better and you will recoup your money as far as you are alive and you are doing surrogacy practice. But she has given it to us free of charge at no cost. Please help me celebrate our facilitator. Also help me celebrate yourself for being here for 2 days. It is indicative of your thirst for this knowledge. It is indicative of your push for growth, and it's also indicative of your desire for mastery, at least carving a niche for yourself. So thank you very much. Our gratitude will always go to the executive of the Gariki branch of MBA for approving this webinar. Yes, we are a committee. We initiate ideas and forward. If it is not approved, it ends there. So we thank our executive and particularly the chairman of the branch in absentia, in the person of Bamidele Ojo Anthony, for graciously approving, and not just approving, but giving us full support. Ladies and gentlemen, we'll come your way sometime in February. We are thinking with 2 topics. One is euthanasia. We are discussing with a professor in that angle. And we are also looking at, we had done medical negligence litigation before, but we are bringing another dimension to it. Whichever comes first due to timing and schedule of the facilitators. We'll look either looking at euthanasia or medical negligence in motor accident litigation. These are areas that once it happens, we just say it don't happen. Thank God you are even alive. We do not know that we have rights. We do not know what steps to take. What we are doing is to bring to the fore the different aspects of medical law practice, because it is actually an untapped gold mine in Nigeria. The traditional litigation appears to have been saturated. So what we are trying to do is to look at these emerging areas where lawyers can, particularly young lawyers, can easily develop themselves and see what they can make out of that profession. Thank you very much. And on the count of three, we will be shutting down the platform. 0, 1, 2, and 3. Thank you all.